Good evening, class. My name is Dominique Pucci, and I did research on wrongful convictions. There has been a rise and release of wrongful convictions, which makes it a topic of discussion as to why and how are innocent individuals being convicted. While every race has been convicted on some level, people of color are more susceptible to being wrongfully convicted than any other ethnic group. Here's our overview. We'll be discussing racial disparities, systemic racism, prosecutorial misconduct, look at a few case studies, and end with some reform ideas. First, in racial disparities, we look at police brutality. As we all know, police brutality remains a severe problem across much of the United States. Current videos and reports of black Americans being either beaten or murdered by law enforcement has empowered a countrywide uproar. The killings of Rayshard Brooks, Breonna Taylor, George Floyd, Dante Wright, and so many others by police deliver significance to the systematic disappointment of criminal law. Whether a police officer may or may not pursue a certain individual is based on their behaviors and if they fit the quote unquote profile. This leads me to my next topic, which is racial profiling. Racial profiling is more common with traffic stops, but the point here is that the use of race, ethnicity, and other demographics is being used as a foundation for criminal suspicion, and some police officers find them using it disproportionately. The question here is whether racial profiling is legal, fair, ethical, or effective. Some statistical data is displayed here. According to the NAACP, while black Americans only make up 13.4% of the populace, they make up 22% of fatal police shootings. Is implementing a law to stop Hispanic members to verify their immigration status? Or is TSA giving special attention to Middle Eastern men because Homeland Security has placed the terrorism threat level at its highest an advantage? To some, the answer is yes. Police must stop undocumented immigrants or may have to prevent the possible next terrorist attack. What's the disadvantage? This causes a disadvantage for all members of that targeted community. Next is systemic racism. This definition is stated here. Systemic racism also extends back to our founding document of the United States Constitution and its several provisions that protected slavery. For roughly 90% of our country's history, which is about 350 years, slavery and legal segregation were in place as a conventional oppression of black Americans. While our country has never recouped from that white on black oppression, systemic racism encompassed in an expansive range in our society through its founding and ideology. During the early origination of our colonies, slavery was not an unquestionable status for Africans, but rather for Christian versus non Christian. The colonial law prohibited a Christian from owning another Christian as a slave. For white laborers to maintain control, they took the religious distinction and merged it with the physical one, in which they assumed that Africans were not Christians, further justification between enslavement and darker skin. In 1640, John Punch was an African slave in Virginia who escaped and was later sentenced to enslavement for life based on his skin tone and not from any English or Virginian common law. The case of John Punch was the first legally endorsed case of oppression by skin tone and may have set precedent for a lifetime. Next came slave patrols and black codes. Slave patrols emerged in the antebellum South as a means to govern and recapture fugitive slaves. These slave patrols are a historic predecessor to modern day police, along with its often violent tools and approaches against people of color. After the Emancipation Proclamation in 1863, Southern state enacted these black codes, which overtly indicated to skin color rather than status of slave. The codes developed crimes that were used to legally re enslave free black people and demonstrated direct power over black lives. Next is causes of conviction. Prosecutorial misconduct can be described as substantial manipulation of authority in the judicial process by police or prosecutors that in turn play a role in the conviction. This graph shows the number of exonerees from 1974 to about 2016, and the spike in this graph vary among many factors, and those factors are listed here. Forensics evidence. This graph is the same graph previously shown, which shows the number of exonerations from 1974 to about 2012 this time, in which the NRE mentions invalid, improper forensic science convictions related to accredited laboratories. The higher number of the accredited laboratories, the lower chance of improper forensic science convictions there were. Out of 103 DNA exoneration cases below, 55% were black, 38% were white, and 7% were Hispanic. Forensic evidence leads us to forensic expert decision makings. Experts are frequently too exposed to irrelevant information in their line of work because they work closely with the police and prosecution. Irrelevant information includes a suspect's ethnicity, their criminal record, eyewitness identification, and so on. Everything this can establish is a bias. Establishing this bias can lead experts to work from the suspect to the evidence instead of allowing the evidence to drive the forensic decision making process. In theory, the person gathering the evidence should not be the one analyzing it. Eyewitness identification has become more unreliable in the legal system by psychological science over the past 30 or 40 years. Misidentification has been known to have played a role in 70% of the 353 convictions that have been overturned since 1989. The act of testing memory over and over again contaminates it when the witness is identifying a suspect, innocent or guilty. The graph in this slide shows exactly that. The initial test of the eyewitness memory is the only test that's to be considered untainted forensic evidence. Considering exoneration, innocent black Americans are 7 times more likely to be convicted, and of those convictions, 50% are more likely to be innocent. Even though there's only about 50% of murders by black Americans with white victims, they're more likely to be innocent if their victim is white. With the facts stated, roughly 22% of black defendants were more exposed to police misconduct. In terms of jail times, a black exoneree spent on average 3 years longer before release, and those sentenced to death spent 4 more years. The National Registry data of exonerations are reported in this graph as of October 30th of this year. Black Americans also received longer prison sentences than their white counterparts while spending 4.5 years longer before being exonerated. While Black Americans, on average, use illegal drugs the same rate, innocent Black Americans are 5 times more likely to go to prison and 12 times more likely to be convicted. In the research of wrongful conviction, case studies were studied in depth to provide a real life experience of individual cases who were wrongfully convicted of crimes they did not commit. This data is accessible through numerous websites, but for this study, I chose the Innocent Project website to share their stories. The first case is that of Malcolm Alexander. His alleged crime was sexual assault, in which he served 38 years being wrongfully convicted. In 1979, a white victim was raped in an antique store in Louisiana by a black man at gunpoint. 4 months later, Malcolm Alexander, 20 years old at the time, had a consensual encounter with a white woman. She asked him for money and then later accused him of sexual assault. The case was unproven and later dismissed. This event prompted police to put Alexander's photo and place it with others when showing the victim 4 months later. The owner hesitantly chose Alexander's photo, and in a lineup which was conducted 3 days later, the word tentative was written next to Alexander's number. By the time trial came around, which lasted 1 day, the owner testified that she had no doubt that her attacker was Alexander. During the trial, the rape kit was accessible but was never pursued. The owner's identification was the only evidence presented at trial. The jury found Malcolm guilty after 1 hour of deliberation, and he was punished to life in prison. Alexander's attorney failed to make a court appearance, failed to challenge the identification, and failed to make opening statement or call any witnesses. Due to the circumstances stated above, the Innocent Project took Alexander's case in 1996. Even though the rape kit was destroyed only 4 years after the initial conviction, hair evidence was recovered in 2013, which did not match Alexander's nor the victim's. The DA's office vacated his conviction and dismissed his indictment. The contributing factors for this case included eyewitness misidentification, government misconduct, and inadequate defense. The next case is that of Huey Burton, whose alleged crime was murder, in which he served 19 years. On January 3rd, in 1989, Huey Burton, at the age of 16, came home from school to find his mother stabbed to death. Burton had no criminal history and was taken into interrogation by 3 detectives who used psychologically coercive techniques such as isolation, threats of criminal charges, and offered leniency if he confessed. Police finally coerced a written confession, and he accidentally killed his mother. After leaving the police station, he recanted his confession. Emmanuel Green was known to be driving Mr. Burton's mother's car and was arrested 5 days later. The same 3 detectives who interrogated a false confession from Mr. Burton were the same detectives who received a statement matching the theory of the crime. Before the trial, Mr. Green was killed and never testified. At trial, Mr. Burton's defense attorney called an expert to testify on the undependability of his confession, but the court rejected the request. Huey Burton was later sentenced to 15 years to life in prison. Mr. Burton's legal team discovered new evidence that the psychological coercive techniques used by the detectives applied to the facts of the case, and the confession was considered false and unreliable. Mr. Burton's legal team produced new information that Mr. Green's criminal history was that of attempted knife robbery and violent rape, which strongly supported that he was the one who killed Miss Burton. Ms. Burton's conviction and sentence were vacated and dismissed in 2019, and then by then, Huey Burton had carried a wrongful conviction for approximately 28 years. Contributing causes for this conviction was false confession and prosecutorial misconduct. My engagement activity. I currently live in Utah and I chose to research the Rocky Mountain Innocent Center, which works with Utah compensation laws. RMIC works to prevent wrongful convictions of innocent people in Utah, Nevada, and Wyoming. One of their exonerees is Andrew Johnson. Andrew Johnson served 24 years in prison for sexual assault and aggravated burglary in which he did not commit. In 1989, the police in Cheyenne, Wyoming received a call from a woman who reported hearing glass break in the house next door, where police arrived at the house to find a woman in the bathroom and found the ID card of 39-year-old Andrew Johnson. Sh- She said the rapist was Johnson, whom she had been drinking with the night before. Police went to Johnson's home, arrested him, and charged him with rape and burglary. A crime laboratory analyst said that the blood tests on the semen recovered from the victims showed that Johnson was within 5% of the population that could have left the biological evidence. In September 27th, 1989, the jury convicted Johnson. He was sentenced to life in prison. In 2008, the RMIC discovered evidence of an alternative suspect, the victim's fiance, that had engaged in abusive behavior toward her in the past, and Johnson's defense attorney had never attempted to determine whether the fiance was actually out of town at the time of the attack, as the victim claimed. In 2012, DNA testing in Johnson's case and the motion was granted, which was the first in the state's history. In 2013, the test excluded Johnson, and the biological evidence identified the DNA profile of the victim's then fiance. The DA's office dismissed the case, and Mr. Johnson was granted actual innocence. He was exonerated by DNA, and the contributing factor was eyewitness misidentification. I'm sure the list is forever ongoing, but some reform ideas for racial profiling and to combat police brutality would be training police officers, implementing more community based policing, and public safety programs where mental health physicians, emergency medical personnel, or crisis resolution members are available and better prepared to handle life or non-life threatening circumstances. To combat systemic racism, we as a society must pursue systemic equality, reduce racial disparities by pursuing to change policy regarding bail reform, plea deals, and convictions. And when it comes to the forensic evidence and expert biases, a good start would be the linear sequential unmasking, which practices minimizing suspect driven bias in which experts are only show the target suspect after they have fully examined and documented the evidence. For eyewitness identification protocols, they should not only adopt best practices, but the initial statement of confidence should be obtained. Police patrol black neighborhoods and arrest them excessively. Prosecutors indict black Americans excessively, and judges give black Americans excessively long sentences. Lastly, is the reference page. This shows the data in which I used to conduct my research on wrongful convictions. I hope this research was beneficial in that it examined racial disparities, systemic racism, and prosecutorial misconduct by gathering qualitative and quantitative data through its solidification. The presentation discussed evidence to show that people of color, from the moment before they are arrested up until they enter the American judicial system, are subjected to being falsely imprisoned.